Welcome to the podcast, Town Hall with State Representative Gino Bulso, District 61. Representative Bulso proudly represents his fellow Williamson County resident and holds town hall gatherings to hear directly from them. These podcasts will continue throughout the duration of the 2023 legislative session of the Tennessee General Assembly. Along with attendees, Representative Bulso will discuss the bills he has filed or co-sponsored in the House. He will review the recent events in the General Assembly, and he will preview the upcoming legislative activity for the state of Tennessee.
Good afternoon, everyone. We are now live streaming on our Facebook page this second town hall that we have brought together a number of constituents from across the district just to keep everyone advised and informed about what's going on in the General Assembly, and in particular, what it is we're doing in the General Assembly. And I'd like to start this week by just taking a review of what has happened of significance on the bills that I have filed in the General Assembly and show what is going to be coming up with those bills in this next week beginning on February the 20th of 2023. And this will act as a very handy template for talking about a lot of the issues that are important right now to, I think, all of the constituents across the district. And first, as you can see, we've got next week a number of bills that are coming up on Tuesday, the 21st of February. And as you can see, we've got at 1:30 p.m. in the Civil Justice Subcommittee, 3 different bills that I have filed that are going to be brought before the Civil Justice Subcommittee for a vote. And if the vote is successful, they will go on to the full Civil Justice Committee, and from there on to calendar and rules. The first one, as you can see, is House Bill 239. So let's go ahead and toggle over to our General Assembly website and see exactly what HB 0239 is. Okay, here, as you can see, this is a bill that I've introduced with a number of different co-sponsors, co-sponsored by Leader William Lamberth, Andrew Farmer, who's chairman of our Civil Justice Committee, Kip Capley, and Rusty Grills. And this particular bill is one that seeks to amend as you can see, section 1-3-105 to define the term sex in the code. And what's interesting about this is that, over the course of the history of Tennessee, the General Assembly has used the term sex in the law a total of 275 times. We know because we've counted. We've gone through, and it's been used obviously in a number of different contexts over the years. And both in Tennessee and across the country, there is starting to become some lack of clarity, you might say, in what that term actually means. So what this particular bill does is it sets out that the term sex, as used in the Tennessee Code, refers to a person's immutable biological sex as determined by genetics and as evidenced by one's original birth certificate. This is actually a bill that has already generated some controversy and some interest in the news media. In fact, many of you may have seen this News Channel 5 article, News Channel 2, excuse me. Let me go over to their website.
legislature would officially define the term sex as what is listed on a person's birth certificate. Chris O'Brien has a closer look at this legislation and also the opposition to it.
Brentwood Republican Representative Gino Bulso filed a bill that would define the term sex as a person's immutable biological sex as determined by anatomy and genetics existing at the time of birth. He says it's not an anti-LGBTQ bill.
Our goal is to help people, not to harm anyone. And what this does is provide clarity as to what a statute meant when it was enacted by the General Assembly and signed by our past governors.
I asked him what his response would be if people argued this bill unfairly targets the LGBTQ community.
My response would be that the bill actually provides clarity for a term that's already in the code. And the greatest gift that any legislature can give to the judiciary is a clear, succinct piece of legislation.
It's a response Democrats take offense with.
We weren't born yesterday. We know hate when we see it, and we will call it out when we see it.
Knoxville Democratic Representative Gloria Johnson echoed a sentiment Democrats have been pushing lately, that these types of bills aren't necessary given the other problems in Tennessee, like issues with DCS, low teacher pay, and rural health care.
It's interesting that all these bills that we absolutely don't need somehow have to do with the LGBTQ community.
Still, Bulso feels confident.
Do you expect some sort of opposition from the other side?
Frankly, I don't. I mean, I think it's so obvious that when the code uses a term, it's important to be clear about what it means, that this bill will likely, I think, pass overwhelmingly in both houses.
With a Republican supermajority, the possibility certainly exists. In Nashville, Chris O'Brien.
Keep in mind, currently Tennessee is one of 4 states in the U.S. that does not allow people to change their gender designation on official documents. Montana, West Virginia, and Oklahoma are the others.
Stop dreaming and start.
So you can see that something as simple as defining a term that's been used in the code for several hundred years is generating this kind of blowback and this kind of controversy, even though I don't think anyone could credibly even suggest that when the General Assembly has used the term sex in the code previously, it was referring to something other than male and female, man or woman, boy or girl. But in any event, this is going to be one of the bills that we're going to be deliberating over in the General Assembly next week in the Civil Justice Subcommittee. The next one is HB 1087, which you may recall that we talked about at our town hall 2 weeks ago. This is a bill that actually just fills a gap in the law with regard to this thing called uninsured motorist coverage. And it's something that is designed to take away a lack of clarity in the existing statute with regard to when a person who's been harmed in an automobile accident can bring into a case a non-party that a person's uninsured motorist carrier claims might be partially at fault for causing some injury. So I won't spend too much time focused on that one today, but we can come back to it if anyone has questions about it as we move along. The third bill that I've introduced is actually a resolution that'll be before the Civil Justice Subcommittee once again at 1:30 p.m. on Tuesday. This is House Resolution HR 0007. And this once again gets a little bit into the weeds, but if we toggle back to our General Assembly website, you can see that this is also a resolution that I've introduced, and this is actually something that we do as a matter of course every year. Many of you know that in addition to being an elected state representative, I've also been serving for the last several years as the chairman of the Supreme Court's Advisory Commission on the Rules of Practice and Procedure. That's something the Supreme Court appointed me to, about 6 years ago to be on the commission, and I've been serving as chairman for the past 2 years. And every year, we actually get together with the Supreme Court and decide on certain revisions that might need to be made to the existing rules that govern practice and procedure in our civil courts. So this includes rules of civil procedure, rules of evidence, also rules of criminal procedure, Rules of Juvenile Procedure. And so what's going to happen next Tuesday is that in the Civil Justice Subcommittee, we're going to take a vote on this package of rule revisions that has been approved by the Advisory Commission that I'm the chairman of, as well as the Tennessee Supreme Court. And then if that actually passes the subcommittee, it'll go on to the full Civil Justice Committee, and then from there on to our Calendar and Rules Committee. Now also, on Tuesday of next week, we're going to be deliberating at 4:30 in the afternoon. And I should also mention that these hearings that we're going to be having on Tuesday and all of the committee hearings at the General Assembly are available live on the General Assembly's website. So if you ever want to watch either a live session of the House or a live session of any of the meetings of any of the committees or subcommittees, you're able to do that just by logging on to the General Assembly website, capitol.tn.gov, that's capital with an O, and then hitting videos and then just toggling down to the particular committee meeting you want to watch. But in any event, we're going to be debating at this time HB 306. Well, what is HB 306? Here we can go to the General Assembly website, and this again is something that we touched on at the last town hall 2 weeks ago. But this is a bill that, let me get to the amendment here. This is a bill that seeks to provide further protection to girls' athletics in non-public schools. And this language that you see here is actually going to be revised based on some discussions that we've had with the Office of Legal Services at the General Assembly. But in essence, last year the General Assembly passed a bill that provided that any public middle school or public high school student who's participating in an interscholastic sporting event has to participate in accordance with that student's biological sex as evidenced by the child's original birth certificate. The General Assembly did not address any non-public schools last year because at the time it was not certain that it actually had jurisdiction to go into a private school or any non-public school and pass a law that would be enforceable. But one thing that I noticed when I became a member of the General Assembly is that any of the schools that participate in our Tennessee Secondary School Athletic Association, which is also known by the abbreviation TSSAA, is going to have to comply not just with that association's rules, but also with any statutes that govern TSSAA. Because our Supreme Court back in 2001, in a case that actually arose out of Brentwood, Tennessee, involving Brentwood Academy, found that TSSAA was known as what's called a state actor. That is, when TSSAA takes an act, that's considered to be an act of the state government. So what this bill is going to do when it's introduced on Tuesday is to require that any school that participates in TSSAA have all of its student athletes participating in accordance with the student's biological sex as determined by the child's original birth certificate, just as all public school students now have to participate. So that's going to be, once again, a bill that we expect significant opposition to. There is already a panel of witnesses who are lined up to testify against this bill on any one of a number of grounds. So if you all had time, or any of you at home watching had time to watch this particular committee meeting at 4:30 on Tuesday of next week, it might well be worth your time because you would actually see democracy in action, both the supporting views in favor of that proposed legislation and the competing views. Now also, next week, on Wednesday, we're going to have 3 more bills that I have introduced, debated in the Civil Justice Committee. This is the full Civil Justice Committee, and in the Cities and Counties Committee. Let's first, if we could, just take a look at what's going to be at issue in Civil Justice a Wednesday at 12 p.m. This is going to be House Bill number 39. And when we toggle back to the General Assembly's website, let's take a look at House Bill 39. This, once again, is a bill that I've introduced. It's being sponsored by Senator John Stevens in the Senate. And this one, I believe, is once again something we discussed at the last town hall. This again is something of a technical revision to the rules that govern our court system. This is a bill regarding what costs a successful party on appeal may recover. It's a bill that has already been successfully brought through the Civil Justice Subcommittee and is now before the Civil Justice Full Committee on Wednesday. We're not expecting any substantial opposition to this bill. This, once again, is an issue that originated with our Supreme Court, arising out of a case called Milan Express versus Navistar from just a few years ago. So this is, again, just part of putting together the infrastructure of our court system. We do not expect there to be much controversy or debate over this particular bill when it gets before the full Civil Justice Committee next Wednesday. Now also, next Wednesday, we've got a couple of bills in the Cities and Counties Commission, and that's going to be at 3:30 in the afternoon on Wednesday. And we've got 2 bills that I've introduced, House Bill 335 and House Bill 336. And both of these are bills that were suggested, you might say, by our city manager here in Brentwood, Tennessee, Kirk Bednar. And they address issues that, in connection with the operation of the city of Brentwood, they recognize an opportunity to make government more efficient. And when Mr. Bednar and Mayor Ray Little actually approached me about these ideas, it seemed to me that they had significant merit and they warranted being brought before the General Assembly. So if we take a look at the General Assembly website, we can look first at HB 0335. And I should mention that both of these bills are being co-sponsored by our state senator from Williamson County, Jack Johnson, in the Senate. And HB 335 deals with how we go about electing a city commissioner, either in Brentwood or at any city across, or municipality across the entire state. Because recently in Brentwood we had a very unusual event. We actually had a special election for a city commissioner just after Christmas. All the parties were campaigning throughout the Thanksgiving, Christmas, and New Year's holidays, and then early voting was just after New Year's, and then actually the election itself was after New Year's as well. And what we noticed about this was that there could be an improvement so that when we have future special elections, they could be aligned with an existing general election to save the taxpayers the costs and inconvenience of a whole nother election. And what happened in this particular case here in Brentwood is that one of our beloved city commissioners, Regina Smithson, passed away, unfortunately, unexpectedly in August. And under the existing statute, the city commission could have voted to fill that seat, or it could have called a special election. But under the existing statute at the time, they had to wait 90 days to notify the Williamson County Election Commission that there was a vacancy that needed to be filled. And because the commission decided not to appoint someone to that seat, they had to wait the 90 days, notify the Election Commission of the vacancy, and then an election was scheduled. Now, unfortunately, all of that occurred in such a way that we couldn't have the special election for the Brentwood City Commission on the first Tuesday of November, when all of the other state races were being decided, and as well as some federal races, as you all will recall, the U.S. congressional seat among others. And so what this modification to the statute is going to do is to get rid of that 90-day waiting period. And so if passed, what this statute would mean would be that where you have an unexpected vacancy, such as we unfortunately had in August of 2022 here in Brentwood, the City Commission can either vote to fill that vacancy, or it can immediately notify the Election Commission that there needs to be an election. And so long as that happens 75 days before the election, we can combine the special election with the general election, which takes away the additional expense and inconvenience on voters of having to go to the polls twice, once in November and then once in January. So we feel that this is a very valid piece of legislation that we expect all the cities and municipalities across the state to support, and we're hopeful it's going to pass the committee, the subcommittee here, on Wednesday of next week. Now recall the second one in the Cities and Counties Commission is House Bill 336. And this once again is something that's being introduced in order to make government just a bit more efficient. Again, it's being co-sponsored by Jack Johnson in the Senate. And House Bill 336 would increase from $10,000 to $25,000, the level at which any municipality would be able to enter into a contract for goods or services that are needed without having to submit the issue to competitive bidding. Because right now, the way the law is structured, if you have Brentwood, Tennessee, for example, or Franklin, Tennessee, if in fact you have to engage in a contract with a vendor for goods or services in excess of $10,000, you have to put that out to bid, which is something of a cumbersome process. Given inflation that we've had and the fact that this statute has not been addressed in a good number of years, if this bill is successful, what will happen is that that threshold of $10,000 will simply be raised to $25,000, meaning that city mayors, city commissions across the state can now enter into contracts below the threshold of $25,000 without having to get the competitive bids and go through the process that currently is required under the statute, which obviously is part of our Cities and Counties Code Title VI here in Tennessee. But that is not all, ladies and gentlemen, for next week. In addition to those bills, we actually have got two bills coming up on the calendar and rules agenda for Thursday the 23rd at 8:30 a.m. And the first one that's going to be coming up is HB 0038, which you may recall we did spend a considerable amount of time on 2 weeks ago at our town hall. Here, let's get back over to the General Assembly website. This is one of the more substantial pieces of legislation that I, as your representative, have proposed in the General Assembly this year. This is the bill, the 10th Amendment bill, that would allow the state of Tennessee effectively to rein in our federal government with regard to its overreach and its out-of-control spending. And we have tweaked the language of this bill slightly at the request of the Attorney General's office, because this is something that I've discussed personally with our Attorney General, a wonderful Attorney General, Jonathan Scrimetti, and his Chief of Staff. But the essence of it is that if in fact there's a need that should arise, which in our view there is, the Speaker of the House and the Speaker of the Senate jointly can retain additional counsel to bring a case directly in the U.S. Supreme Court to address Tennessee's fundamental constitutional rights under the 10th Amendment. And this would arise under what's called the Spending Clause, also known as the General Welfare Clause. It's Article 1, Section 8, Clause 1 of our Constitution. And I'm happy to report that this bill has not only passed out of the Public Service Subcommittee, which is where we started, but it also passed earlier this week in the State Government Committee, which was its next stop. And so now it's on its way to calendar and rules next Thursday, which means that this very piece of legislation is going to be on the House floor in 2 weeks. And this will actually be the very first bill that I stand up in the well of the House of Representatives and argue to my colleagues in the House that should be passed. And I can show this. It's only going to take about 4 minutes. So if you'll indulge me for just a moment, this might actually be instructive as to how you go about finding these videos on the General Assembly website. If we look at committees, we'll go to the House on the General Assembly website, and we're going to toggle down to State Government. And here, of course, is our team of State Government Committee. Kelly Kiesling's the chair, Rick Eldridge is the vice chair, and then, of course, it's got a total of about 16 other members, so a total of about 18. And you can see I just hit the video link on the State Government Committee, and I'm going to toggle down, and there's a video button here. And we hit that video button from February 15, so this is just 2 days ago, and it's going to take us to the actual debate or presentation for this very bill. And let me see if I can move it all the way to the right spot here.
Microfilm has been all but and sir.
Thank you, Mr. Chairman and committee. House Bill
Good. All right, we've had a call for the question. I see no objections. Let us proceed. Voting for those in favor, please say aye. Those opposed, like sign. Ayes have it. And Chairman, you're moving on to also the calendar and rules, sir. Congratulations, and have a good ride up through the canyon there.
Thank you.
Now, what we're about to see is the presentation of this 10th Amendment bill before the State Government Committee on Wednesday. It lasts about 4 minutes.
All right, and finally coming in at number 4, we have House Bill 38 by Representative Bulso, and I see you have an amendment on here. We're going to ask you for, we've got a motion and a second on the bill. Next, we're going to move on to the amendment, and would you please give us your tracking code, Representative, for amendment number 1?
Happy to, Mr. Chairman. Tracking code is 003868.
That is correct. That is correct. So we haven't, yes, thank you for that. We have a motion, also a second for the amendment. Okay, any questions on the amendment to the sponsor? See none. Let's vote. Those in favor on the amendment. Those in favor, please say aye. Opposed, like sign. Ayes have it. Amendment is now on House Bill 38. Representative Bulso, you're recognized, sir.
Thank you, Mr. Chairman. This is a bill that seeks to amend one of our existing statutes, titled 8-6-106 of the Tennessee Code. It seeks to add as subsection C a new provision that authorizes the Speaker of the House and the Speaker of the Senate jointly to retain counsel in addition to the Attorney General's office should the need arise. The bill further specifies that the Speaker of the House and the Speaker of the Senate jointly can retain counsel to file an action in federal court for the purpose of vindicating Tennessee's constitutional rights. It further provides that counsel would be retained at no cost to the state. In other words, counsel would be providing the legal services as a public service without a fixed legal fee or a contingent fee. So
So the question obviously before the committee is there a need for this statute, for this amendment to 8-6-106? And the short answer is yes, for two reasons. First, the short answer, and then the long answer. Currently, the law obviously allows the state attorney general to file an action in state or federal court on behalf of the state or to defend a case. And that is pursuant to 8-6-101, a statute that this body passed many, many years ago, because our Constitution, our state Constitution, Article 6, Section 5, specifies that the Supreme Court is to appoint an attorney general and reporter, but does not set out what duties and responsibilities the attorney general actually has. This body did that in 8-6-101. Also, in 8-6-106, this body gave the governor the authority to retain counsel in addition to the Attorney General's office, should the need arise, to represent the interests of Tennessee in state or federal court. That is a provision that has been used over the years. In my personal experience, Governor Sundquist asked me once in 2001 to represent the state in federal court on a constitutional issue pursuant to this statute, 8-6-106B. And Governor Haslam also, under the same statute, asked me to represent the state in 2013. But there is no provision anywhere in Title 8, Chapter 6, that actually gives the General Assembly the ability to bring a case on its own behalf should the need arise. And this came home to roost, so to speak, in 2019, when the action that this body filed regarding refugee resettlement was dismissed both by the Federal District Court and by the Sixth Circuit Court of Appeals on the basis of lack of standing. Both those courts ruled that although there was statutory authority for the Attorney General to bring an action in federal court, and there was statutory authority for the governor to do so, there was no statutory authority for the General Assembly to do so. That case was initiated with a Senate joint resolution that did not have the force of law. So without ever getting to the merits of that issue, where the state of Tennessee brought a case against the United States Department of State, the case was dismissed because there was no statute such as the one that's before the committee this morning that would authorize the General Assembly to bring an action on behalf of the state should the need arise. So in short, what this bill does is it puts the legislative branch on equal footing with the co-equal branches of government, such that the judicial branch can obviously bring a case pursuant to the Attorney General's office under 8-6-101. The governor can do so under 8-6-106B, and if adopted, the General Assembly could do so under this new provision, 8-6-106C. So that's, Mr. Chairman, the structural reason that this bill is necessary.
Okay.
And then the longer view is that if this bill becomes law, my plan would be to ask Speaker Sexton and Lieutenant Governor McNally to retain counsel on behalf of the General Assembly to bring an action under the 10th Amendment in federal court under the original jurisdiction of the U.S. Supreme Court to rein in federal overreach and federal out-of-control spending, which is a topic we can discuss in further detail.
Sure, thank you. All right, yes, we do. Okay, we want to recognize Representative.
So it goes on for a while from there with questions from the committee, but that's effectively how democracy works. If you're a representative, you propose a bill, you get up in front of a committee, you do your best to explain the nature of the bill and the reasons why it's necessary. And then if all goes well, you'll get a vote affirming the proposed legislation. It'll go on to the next step. And here, that next step is going to be calendar and rules. As I mentioned a moment ago, on Thursday, February 23 at 8:30 a.m. That'll be the first matter taken up by the Calendar and Rules Committee, and if we are successful there on Thursday, on the following Thursday, which obviously will be March the 2nd, because we only have 28 days in February this year, on March the 2nd, we'll be presenting this bill to the entire House of Representatives where, God willing, it'll be approved, and then we start moving it in the Senate through Senator John Stevens, who is moving the legislation through the Senate. And then also, we've got calendar and rules, a House joint resolution, just a House resolution, 0008, that has already gone through the committee process. And if we toggle out to the General Assembly website, we can see that House Resolution 0008 is, once again, a resolution that seeks to approve amendments to our rules of criminal procedure. And this, once again, is part of the housekeeping, you might say, the infrastructure of our criminal justice system. Just as we saw a moment ago that we've got revisions to the rules of civil procedure, they're going to be working through the Civil Justice Subcommittee. We also have got rules of criminal procedure that have already been through the Criminal Committee and are going to be now before Calendar and Rules. One final item that I will note that occurred of interest this past week is that we had a hearing on Wednesday in the Civil Justice Committee, which was interesting because we got to interview a proposed nominee to the Supreme Court. Many of you may be aware that one of our Supreme Court justices, Sharon Lee, announced a few months ago that she was retiring this coming August. And Governor Lee has selected a very, very fine lawyer, Dwight Tarwater from Knoxville, to fill her seat. And Dwight Tarwater is actually someone who I know well, who I've actually litigated against. And so it was kind of fun questioning him about his qualifications to be on the Supreme Court with that background. That was kind of an entertaining part of the hearing. But then there was debate over this thing called House Bill 1. And this is the bill that Leader Lamberth has filed in the House and Jack Johnson has filed in the Senate that would prohibit Vanderbilt and other institutions from engaging in what's referred to as gender mutilation surgery, where you actually remove a child's body parts and give a child hormones and other puberty blockers and other medications in order to, in some sense, change the sex of a child. And that obviously is an issue over which there is, once again, a lot of controversy, and there was a lot of blowback both when that bill was before the Public Health Committee, and we saw that again on Wednesday when that very bill was before the Civil Justice Committee. And it had to go to the Civil Justice Committee because the remedies that are in that statute, if it's violated, are in the civil justice system. So both the Health Committee and the Civil Justice Committee had to approve it. And once again, this was something that actually made the news. And let me, if I could, go to Fox 17's website. And this is a newscast from Fox 17 on Wednesday night.
This small thing is the next big thing in diabetes. It shows your glucose and predicts where it's headed. Management.
And before I play this, I want you to pay close attention to the implicit bias that exists in the media. Because rather than having language that is neutral, that allows viewers to make up their own minds, watch the way they refer to the medical procedure that the bill seeks to prohibit because it involves, in the bill's view, mutilation of a child. It's very similar to the entire abortion debate, where those who favor abortion refer to it as health care. Obviously, those who oppose it refer to it as the unlawful taking of an innocent human life. And oftentimes in the media, you can see an implicit bias with regard to how they actually introduce an issue. So keep that in the back of your mind when watching this.
Permanent change on my child by passing this bill.
Continuing coverage now as Tennessee friends like that woman you just heard from share emotional testimony as state lawmakers advance a bill banning transgender health care for minors.
Well, this includes surgical procedures and prescribing puberty blockers. Fox 17 News' Jackie Del Pilar live downtown after sitting in on that hearing today. Jackie?
That hearing happened right here in this building beside me, and it also passed the full House, or the full Senate on Monday. Now, supporters of the bill say it's all about protecting children from irreversible changes to their bodies, but opponents say it could cause more harm than good. The bill aims to ban gender-affirming care for minors, like puberty blockers and hormone treatments. It would also ban surgeries altering a person's sex assigned at birth. Supporters say it's to protect children from changes they might regret.
It's not unreasonable to say that type of a decision of that magnitude should wait until you're an adult.
But parents of transgender youth say this care is what's saving their children, and they're calling on legislators to stay out of their families' private medical decisions.
It would cause real physical, medical harm, real mental health harm. That is harming children.
One parent in a heated exchange with Representative Gino Bulso.
Do you agree, Dr. Bowden, that it is those who support this fiction and this fantasy that a person can change their sex who are causing the harm that we see in children across this entire state?
With all due respect, sir, it is not fiction or fantasy for my family. It is deeply personal. It is extremely difficult to understand if you are not in the situation.
I brought the parents' concerns to bill sponsor Senator Jack Johnson.
And we've heard testimony from some trans individuals who have said that this type of care saved their life, that they would have taken their own life otherwise.
We need to do everything we can to provide mental health treatment to anyone who needs it. And gender dysphoria in the medical community is referred to as a mental illness. And so we need to provide the mental health treatment to people who need it.
The bill now advances to another House committee before it can go to the full House.
A representative from the ACLU also spoke at the hearing today. They say the organization is prepared to sue the state if this becomes law. Reporting live downtown, I'm Jackie Del.
That's the extent of it. I think you heard what I was referring to. They referred to these procedures as, quote, gender-affirming care rather than what it truly is. So that is a bit of an overview of all the excitement that we had this past week in the General Assembly, as well as a preview of what we are going to be doing on behalf of all of you nice folks in the 61st District, Legislative District here in Tennessee. And with that, let me just go ahead and open it up for questions about anything that you've seen or anything you want to talk about with regard to the bills pending before the General Assembly, and we'll bring you a microphone to make sure those listening at home can hear you.
I have a question.
All right. If you could just give us your name first, please. Kathy, and then.
Sure. Connie Regulate. So this question about hiring outside counsel for the legislature, and you say in there that it won't increase any additional state expenditures, I think is the way it's worded. So that outside counsel, how would they be compensated is the first question. And the second question is, I am very concerned because I actually do my own rummaging through the Transparent Tennessee checkbook once in a while to find out where the taxpayers' money is going. And I found that Tennessee taxpayers had paid Waller, Lansden, Dorch, and Davis over $500,000 in a 2.5-year period. And so I did a public records request to the Attorney General's office to get the invoices, the contracts, the agreements to do that, and they want to charge me $1,400 to even have access to those records. So I would like to ask you as a legislator if you would make that inquiry to the Attorney General's office to see why they would be paying that much money to Waller, Lansden, Dorch, and Davis. We know that Waller is also a very big law firm who does, they paid a lot of money to, in 2014, on the constitutional amendment to take away our right to vote for our Supreme Court justices. They paid $75,000 for that. They also do they are a very big lobbying law firm. They have a lot of lobbying. So they're very invested in government operations. And so I'm very concerned about that expenditure. And then, of course, the first question is how would legal counsel be compensated through this new law?
Thank you for both those excellent questions, Connie. First, with regard to compensation under this new law, the answer is that there would not be any. And the bill specifically addresses the fact that any additional counsel that the state would retain would have to provide the services without any fixed or contingent fee or have the case result in any increase in state expenditures. In other words, whoever the state retains will be doing it out of a sense of public service, a sense of patriotism, which actually was the way that the prior case that the General Assembly filed that was dismissed was handled. You may recall that in that case, the General Assembly retained a public service law firm out of Ann Arbor, Michigan by the name of the Thomas More Law Center, and in particular, an attorney named Richard Thompson. And throughout that entire litigation, which as we heard was ultimately unsuccessful because of the standing issue, the state was not charged anything because the firm was doing it as a public service. And this law that is going to be before calendar and rules on Thursday has that same requirement, that it not cost the state anything. Second, with regard to Waller Lansden and the $500,000, I don't know the specifics of that. I know that obviously Waller Lansden's a very good firm, a very well-respected firm. And for whatever reason, the state hired the firm to provide legal services in addition to the Attorney General, likely under this very same statute, 8-6-106. But I can, comment on my personal experience. The one case that I mentioned in the presentation to the state government committee was that Governor Sundquist asked me back in 2001 to represent the state in federal court. And that was because, in part, there was a bit of a conflict between the Attorney General's office and the federal judge who had a case. That was Judge Alita Trauger, one of our very fine federal trial judges here in Nashville. And that case involved a group of retailers, LensCrafters, Pearl Vision, Cole Vision, and others, bringing a case against the governor and the Department of Health, claiming that part of our optometry law was unconstitutional. They claimed specifically that the law violated what's called the dormant aspect of the Commerce Clause, which is Article 1, Section 8, Clause 8 of the U.S. Constitution. Well, the governor asked us to take over, and we signed an engagement letter, and we reduced our hourly rate significantly. I think we reduced it all the way down to $190 an hour. And even though we did that, because litigating against large multinational billion-dollar corporations is expensive, I think that litigation cost the state over $300,000. And that was 20 years ago. And I can assure you that we provided the best, most efficient, cost-effective legal services we could. At the time, I was with a large firm here in town at that time known as Bolt Cummings, Connors & Berry, which later merged with the Bradley Arant firm out of Birmingham. So, Connie, I don't have any specifics with regard to the $500,000 paid to Waller Lansden, but I can just tell you from personal experience that when you get involved in the kinds of cases that our state government is involved in, they're typically very large, they take a lot of time, and they are, unfortunately, very expensive. Great. Thank you for the question. Now, do we have any other questions? Yes, please. Let me just go ahead and give you the microphone if we could. Just tell us first your name and then obviously what your question is.
Hi, Representative Bulso. My name's Steve Hickey. First of all, thank you for a very informative town hall. Very much appreciate the insight into what pending legislation is out there. My question is, I'll preface it by saying, first of all, I wholeheartedly agree that the states need to reassert their 10th Amendment rights to take back certain things from the federal government. I also agree that the legislature needs to reassert itself with regards to the executive. My one concern, though, and I'm sorry I don't have the Tennessee Constitution in front of me, is putting the legislature on an equal footing with the executive to bring suit against the federal government. Is that an encroachment on the executive's privileges per the Tennessee Constitution? Thank you.
Sure. Excellent question, Steve. And the short answer is that no, it actually is not an encroachment. You know, we have got a unique system of governance in Tennessee with regard to the judicial branch, because we are the only state in the entire country that has an attorney general that is appointed by the Supreme Court. In virtually every other state in the country, the attorney general is elected statewide by the people. And there are just a handful of states that I believe have an election by a legislative body, but there's no one else that actually has a Supreme Court appointing the attorney general. And because of that, we have this interesting dynamic where in the Tennessee Constitution, as you mentioned, Steve, we've got Article 6, Section 5 of the Tennessee Constitution that provides that the Attorney General and reporter is to be appointed by the Supreme Court, but nowhere does the Constitution actually list the duties and responsibilities of our state Attorney General. That power to the Attorney General is actually something given to the Attorney General and reporter by the General Assembly. And that is in a statute called that's Title 8, Chapter 6, subsection 101, 8-6-101. And in 8-6-101, the General Assembly vested the Attorney General with the authority to file and defend all cases in all state or federal courts on behalf of the state of Tennessee. Years later, in subsection B of that same statute, the General Assembly vested the governor, the chief executive, with the authority to retain counsel in addition to the Attorney General should the need arise. And as Connie was just asking, and I was also relating, there are occasions where private attorneys represent the state. That's not very common, but it does happen, and it happens for good reason. And so it doesn't really interfere with the governor's authority, because the governor's authority to retain counsel was actually given to the governor by the General Assembly. And so what this bill is doing is it is actually, as I mentioned in the presentation, it's putting the legislative branch on the same footing of being able to retain additional counsel to represent the state in federal court on constitutional issues if there's a need to do so. So it's an excellent question, Steve, but the short answer is no, it's not an encroachment, because under our Constitution, all of the authority to have either the Attorney General, the governor, or the General Assembly bring cases is left to the wisdom of the General Assembly. Sure. Yes, Charlotte, let's, if we could get you a microphone, and please tell us your name, although we know it, and then ask your question.
My name is Charlene Kimmel, and I have actually two questions. I'll make them both quick. HB 883 is the proposed law to clarify the issue of abortion. I read today, this morning, earlier, looks like they've kind of done a real muck-up of trying to get the life of the mother to be in there as to be taken care of, that the mother would be taken care of even if the life of the baby has to be sacrificed. For sure, that has to be in there. That's my stance. I don't think anything else needs to be in there, but that's up to the legislature to decide. My question about that is, it should be a fairly easy statement to make, that should the life of the mother be in danger through ectopic pregnancy, through eclampsia, preeclampsia, and a few other things that will kill a woman while she's pregnant, that they will do their best to save the baby, but the mother's health would have to be primary. Is there anybody medical advising the people who are working on this bill, or advising the committees that are looking at this bill, to give them some background? And, you know, I mean, it should be a fairly easy thing to delineate. Now, I understand, just much as you have done with making defining sex in your first introduction, many things need to be defined in the bill to make it sense. But taking it from a structural thing like that, I think if you must have some either medical people or nurses, somebody who can help the staff and everybody to fix that. That's my first question. The second one is completely different. Several years ago, I think it was, state of Tennessee legislature voted on the state convention to become participants in that. What is your feeling about it? And also, could you give me any thoughts you might have on our constitutional amendment, federal constitutional amendment number 17, which passed the power of electing senators to the people instead of the states? And I'd be interested just to know where you're going with that, although it's not anything that's coming up this session, I doubt.
Okay.
Thank you.
Well, thank you, Charlene. That's quite a plateful. Let's go ahead and just take each one of those in turn. Let's start with House Bill 883 and see whether it's been posted on the General Assembly website. The last time I checked, it was not there. Let's get over here. Okay, this is a bill that was introduced in the House, obviously, as you can see, by Representative Helton, now known as Representative Helton Haynes, and in the Senate by Senator Briggs. And when we look at the original bill, you can see that it really says nothing. It originally just said that there is a proposed amendment to Section 4-8-305 regarding the State Capitol Commission. And this is what's known in legislative parlance as a caption bill, meaning it's just a placeholder. So the purpose of it has nothing to do with what is stated here. You actually have to look at the amendment to figure out what's going on. And so if we look at the amendment page here, it says there are no amendments for 883, which is what Charlene is asking about, and that's not true. There is an amendment, and I've got copies of it that I can pass out to any of you who want it before you leave here today. But this is a bill that many of us are very upset about and going to be working very hard to either amend or to make sure it doesn't get through the General Assembly. Because right now, Tennessee has got perhaps the finest pro-life legislation on the books, as Charlene was mentioning. It protects the life of an unborn child at every level, but it does obviously allow, in the case of having to, you have the unfortunate circumstance where the life of the mother may be at stake. Obviously, the physician has the ability, as does the mother, to act to save the mother's life. And that is something that's currently in the statute, is what's called an affirmative defense. And there's been an effort to weaken that law. And that effort, in part, has taken the form of HB 883. Well, what does HB 883 as amended say? Well, it effectively says this, and I'll preface this by saying this is a bill that was written by the Hospital Association, a lobbying group, on behalf of doctors and medical providers. This was not written by a group of pro-life attorneys or concerned citizens. This is a piece of legislation that was prepared by a group that has, you might say, an interest in the legislation. And effectively what it does is that it guts the existing statute, which is known as the trigger law, that came into effect in August of 2022, just 60 days after the Supreme Court issued its Dobbs ruling on June 24 of this year. And as amended, what this bill would do would be to provide that a physician cannot be prosecuted criminally for any abortion that in his good faith judgment is needed to prevent or to resolve a medical emergency. And it further provides that a physician can engage in an abortion lawfully in the event of what's called a fetal anomaly, a lethal fetal anomaly. And it further provides that if a physician is indicted under the statute, that the physician can appeal to the state medical board for a ruling about whether his conduct complied with the applicable standard of care. And so it's something that has passed a subcommittee, what's called the Population Health Subcommittee, and this is going to be before the full Health Committee this coming week. But I can tell you, Charlene, I've personally sat down and spoken with the chairman of that committee and told him I am available to help redraft this legislation to actually make sure it protects the life of unborn children while at the same time protecting the life of the mother in those types of medical occasions that you mentioned, where you unfortunately have got a pregnancy, an ectopic pregnancy or some other type of condition where the child has no chance of surviving. And in those cases, you know, you certainly have a physician acting in accordance with good medical practice and saving the life of the mother. And one of the things that I think is important here to note is that you can only make laws so specific. You can only pass a law that can handle you can't pass a law that handles every conceivable type of medical emergency. So what the law really needs to do in very simple terms, as you laid out, Charlene, is just to establish that a physician in these circumstances is dealing with two lives, the mother and the child. And in cases where there is a conflict between those two, a physician needs to go ahead and use good medical ethics in determining how to save both patients if that's possible. And then obviously, if it's not, to follow the dictates of the mother and her family as to what should happen. Right now, the bill doesn't do that. The bill opens up Pandora's box with regard to these terms about what's a medical emergency, because medical emergency in the amendment is defined not just as the life of the mother, but a medical emergency is defined, if I recall this correctly, as any instance where the health of a body part of the mother is in jeopardy. So it is unfortunately not really a statute that would provide any realistic protection to an unborn child, because regrettably, I think there are some in the medical profession who do not always act in good faith. And this is a subjective standard, it's not an objective standard, and it expands saving the life of the mother in a way that is almost meaningless, because what does it mean that you might need to terminate the life of a child in order to save the functioning of a body part of the mother? So it's very problematic, Charlene. We are working diligently on this, I promise you. And part of the resolution may be to amend it so that there simply is a listing of the medical conditions in which a physician can obviously go ahead and, if there's that conflict between the mother's life and the child's life, act to save the mother, with the unfortunate circumstance being that the child does not survive. Your second question had to do with the Convention of States. And Tennessee, as you know, is a part of the Convention of States. I fully support that because we've got a number of different arrows in our quiver to address this problem of federal overreach and federal out-of-control spending, which deprives states and local governments of funds they need in order to run their business and to provide for growth and to take care of our communities. And one way is the bill that I'm proposing, where we get those 5 constitutional conservatives in the U.S. Supreme Court involved in the issue. A second way is this Convention of States, which, if they actually obtain the 3/4 of the states needed, you could actually have a balanced budget put into the U.S. Constitution, which is certainly something I'm in favor of, something that's necessary. Frankly, it's something that I think is required by the 10th Amendment already. The 10th Amendment, of course, is the one that says the power is not granted by this Constitution to the United States, comma, nor prohibited by it to the states, comma, are preserved to the states respectively, comma, or to the people. And it read in context, that is a limitation on federal power, because the federal power to spend money is only on 3 things: paying the debt, providing for the defense and providing for what's called the general welfare, which is a whole nother discussion that would take us beyond the time we have today. But no, I'm a proponent of a balanced budget. I'm a proponent of the Convention of States as another way to try to get this issue before the public in general. And then third, the 17th Amendment, which as you correctly identify is the one that provides for direct election of senators rather than the states, is one that, I mean, frankly, I wish it were not there. I think the way the founders set this up was the way it should be, that we have a federal system of government. The place where you determine representation based on the population is in the House of Representatives. But the place where you preserve the federal nature of our government is in the Senate, where you have each of the now 50 states, back then obviously it was only 13, electing 2 representatives. But through the 17th Amendment, we actually made both houses of Congress subject to a popular vote. So is that going to change? No. I don't think there's any realistic chance that we'd have to change the 17th Amendment. We've got other perhaps more pressing constitutional matters facing us, like the bankruptcy of the country, because now we're at 135% of our national debt versus GDP. But that's something that if it weren't there, I would be happy that it weren't there. But it is there, and I think it'll be there for some time to come. But we're just a little bit over time, but thank you all for coming here. Thank you all at home for your participation, and we look forward to seeing you at our next town hall.
Thank you for listening to the podcast, Town Hall with State Representative Gino Bulso, District 61. You can also tune into these town hall meetings live on the Gino Bulso for State House Facebook page. Please share with your friends and family. Thank you, and God bless.